All right, welcome back to the Cordell Cordell virtual town hall. I'm Scott Trout, managing partner and CEO of Cordell Cordell. As usual, we're going to bring you information for guys before, during, and after a divorce. And keep in mind that obviously this isn't legal advice. We can't give that to you in this type of form. We'd only be able to do that in a consult. You can get more information if you want to have a consult with one of our attorneys from around Cordell Cordell. You can go to cordellcordell.com, get more information, or you can give us a call, 866-DADS-LAW, 866-DADS-LAW. We can do it on the phone via technology just like this, Zoom, Teams, or you can come into one of our offices around the country, including the United Kingdom. All right, so we're here to talk about that pervasive thing that's sitting out there, and that is inflation. And now you may be facing a divorce or perhaps a modification or something when you think you can least afford it. You know, prices are out there, everything's costing more across the board, including professional services. And it's one of those things where you need to be thinking about it. And we're going to give you a reason to think about it and probably a reason to take action, depending upon your facts and circumstances. Keep in mind, we'd love to hear from you. You can submit a question. We'll hopefully give you some answers in the second half of our virtual town hall. You can do that via the Q&A section. So if you want to submit a question now, you can do that. We'll get to it later. Just give us your first name, city or state, and then the question. And again, we'll get to those later in the show today. And we'll try to get you some guidance. Obviously, we can't give you legal advice on those questions. We'll try to just give you some education, put you in the right direction, give you a direction to go with that question. But again, best way to get those questions answered is through a consultation, whether it's with us or an attorney who practices exclusively in family law like we do. All right, let's get to it. I want to introduce our panel of Cordell and Cordell attorneys today to talk about inflation, divorce, modifications, the gambit, as we deal with something unique. You know, if it's one thing, it's COVID, it's recession, now it's inflation, and there's always a cause and effect as it relates to family law. So let's go right to Maine, and welcome to the show, Matthew.
Good afternoon, everybody. My name is Matthew Crouter. As Scott Trout said, I am an attorney in Maine. I've been practicing family law for the past 9 years. And I started at a firm that did a lot of family law, but also general practice, which I thought was a great experience because it gave me a wide breadth of knowledge around the legal spectrum, which I thought was important because family law is oftentimes never just family law. There are always tangential things related to it, such as investment banking or real estate, as it comes to division of assets, finances, and so I have found that through my years of experience, I have been able to gain knowledge across the legal spectrum that has then really helped my work as I focus now exclusively in family law.
All right, thanks, Matthew. Let's go to Florida. Presley, welcome.
Hi, good afternoon, Scott. Thank you so much for having me today. I'm Presley Davis. I'm located in Northeast Florida in the Jacksonville office. I have been practicing family law exclusively now for 3 years, and I've been with the firm since October of 2020. And prior to practicing family law, I served as a prosecutor in Florida's 20th Judicial Circuit, which certainly has helped me with several aspects of family law that tend to cross over, including domestic violence cases. But I'm happy to be here this afternoon with everyone.
Thanks, Presley. I'm rounding out the panel over in Illinois. Welcome, Rachel.
Good afternoon, Scott. I'm Rachel Schmidt. I am in the Edwardsville, Illinois office. I practice primarily in Southern Illinois. I have actually been a practicing attorney with Cordell and Cordell for over 15 years, and I'm happy to join you this afternoon as well.
Well, great. We have a good panel today with from around the country. We'll talk a little bit about inflation, and keep in mind, again, submit your questions now. I know you have them. We have some already that we'll get to in the second half of today's virtual town hall. You can do that in the Q&A section. You can do that now. All right. Before we get right to inflation and talking about its effects and how you can afford divorce, or whether you should be filing, or whether you should be filing a modification, we're going to talk about those topics. But first, a very brief message, and we'll be right back.
For many men, divorce casts a long shadow across every part of their lives. Your usual routines and familiar places are no longer inviting, and time spent with friends, even family, is no longer comforting. But you don't have to walk through this alone. We can help. For more than 30 years, Cordell Cordell has guided men through the challenges of divorce. You're not alone. Call Cordell Cordell, a partner men can count on.
All right, welcome back. Let's get right to it. So inflation, you hear it a lot. I want to ask the panel in general here a few questions before we get to individual topics. And that is really, as we think about it, I was mentioning to the panel back in 2006 or 7, I was interviewed by the Wall Street Journal. You're talking about recession, and the reporter said, well, most of your guys, your clientele, they can't afford to file for divorce right now because of the economy. Well, in reality, my answer was they can't afford not to file. When the marriage is broken, they can't afford not to file. And it stopped the reporter for a moment, and the thought being, what do you mean by that? And we're going to get to it, but I think what I take that to mean, and when we talk about inflation, and you really can't afford not to file, again, if your marriage is broken, or if you need a modification, or if circumstances dictate a change to the order. And that is, while you may have difficulty affording the process, the opposite part, meaning that the effect of accruing perhaps arrearages or living in a broken marriage, or you want to file when your assets are at its lowest part. That's what I mean when you can't afford not to. You want to sell high, buy low. In divorce, I'm going to sell low. And at this point, I'm going to divide my asset at its lowest point rather than at its highest point. So that's what I mean. And so I want to talk to the panel. Rachel, I'm going to go to you. And I think for each of you, let's talk about inflation. Let's talk about what we're seeing across the country from the bench, from the court system. Like I had seen in 06 and even in COVID, you start to see an evolving behavior by the courts and then being a little bit maybe more tolerant as to the inflationary pressures or as to the effects on jobs. What are you seeing, at least in the Illinois area, in terms of the court's behavior?
I think the courts are definitely taking recession, the job market into account, definitely. One of the things that I was thinking about when you were talking is about retirement accounts. 2 years ago, you had a retirement account that was, valued higher than it is maybe currently, or it's going to be. So you never know, although right now you may think, oh, I don't have the money to go through this divorce or to go through this modification. My thing would be, you don't know how much worse it could get. So if you're thinking about it now, you definitely need to talk to somebody because you don't know what the future holds, and it could be even worse. Your debts could be higher, your retirement account could be lower. So you definitely don't want to wait if it's something that you're thinking about.
Yeah, and I think that has maybe the temptation, and I get it's a natural reaction where guys will say, look, I'm going to wait till things recover. I'm in a better position financially. I'm in a better place, and I'll just live through it. And I always caution, again, I said it earlier, it's not that I want to, or any of us are encouraging filing just for the sake of filing, but just because it's in a bad economy. The point is that you have to have reached the conclusion that your marriage is broken. I mean, imagine, I've always said I've kicked clients out of the office essentially because they're just not sure that their marriage is over. And I'm like, look, then you need to figure that out and come back. I mean, it's an unusual position to be in as a divorce lawyer by making sure that the marriage is broken. So I'm going to go to you, Presley. What are you hearing? What are you seeing? It's at different times. I mean, we've gone from one thing to the next, from COVID to hyperinflation to, kind of just where it's a little bit, we haven't seen this kind of behavior. And so I'm just curious what you're seeing from the courts.
So in the state of Florida, we have a really high burden for people who want to modify their child support and modify their alimony. I wish judges would be a little more lenient sometimes because there are cases where people really do need that extra relief, but Florida requires that there has to be a substantial change in circumstances that was unanticipated at the time the final judgment was entered. It's got to be voluntary in nature, and it also has to be permanent. And the permanency one is where a lot of people really struggle because we don't know how long we're going to be in with this economy where inflation is really hitting hard. And we didn't know how long we were going to be in a pandemic. So that's something that a lot of people we haven't really, has to be taken into account when you're looking to modify child support and alimony in Florida.
It's a good point. I mean, I think from a judge's perspective, if I'm on the bench, inflation is temporary. We know this. And I mean, it's the same argument where you hear from people in the workforce and they're saying, well, look, I've got more expenses. I need more money. But the point is that, perhaps the raise is permanent when the inflation may last only till summer. We don't know. And I get that from a judge's perspective. They say, look, hey, we don't know. And I'm not going to take action in month one of an inflationary pressure. I understand the problem. I understand it's difficult on everyone. And I think that's perhaps the difference between a job loss because of COVID, which tends to perhaps be more permanent, where we see companies closing, companies right-sizing, downsizing their workforce, whatever it may be. That is a very different situation. However, I do see opportunities, perhaps, and we'll talk a little bit about timing and modifications because of inflation, because of job changes and losses. So, what are you seeing, Matthew, in Maine? Are you hearing similar behavior, comments, conduct from the bench as it relates to kind of this time period post-COVID and inflation?
So in Maine, the courts, once COVID hit and everything sort of a shutdown, they did a complete shutdown for 2 years, where they were just not doing any cases at all unless they viewed them to be emergency in nature. So cases like protection from abuse actions, child protective cases, and the Maine Supreme Court had even determined that a criminal defendant's constitutional right to a speedy trial was trumped by the pandemic. And they eventually resumed criminal cases and family law cases. In some courts, they started going again a year ago, and then in other courts in Maine, they were about half a year ago. So in Maine currently, they have in all of the courts just the largest backlog of cases imaginable, to the point where there are some courts where last week, when they finally started doing general civil cases, so real estate cases, personal injury cases. And so that means that in our office we have some cases that were started in 2019 and they currently have not gone to trial. And we've been waiting over a year for a trial date. And the way I like to refer to the backlog is, the feeling you get when you go on vacation for a week and then you return and you look at the number of emails in your inbox and you want to die. It's that times a million. So when Scott was mentioning, you really can't afford not to file for divorce. In Maine, that is especially true because given the huge backlog they have now, if you've come to the conclusion that your marriage is irretrievably broken, you're not going to be reconciling. If you file today, you are looking at potentially waiting 2 years or even longer if the case goes to trial. And so, I always tell people, once they've made that decision, that you have to look at the current economy and inflation, but you also have to look at the fact that you could be staying married to your spouse for over 2 years, even though you are ready for that marriage to end today. And so in terms of inflation and how the courts are kind of looking at the current economy, I found that their biggest concerns right now is really, we have a Mount Everest sized backlog. How do we clear it? That seems to be their number one concern. And then in terms of inflation, a lot of the judges in Maine, the way they look at things is we have such a huge backlog, and I think the inflation is likely to go down or normalize. and then look at how long it's taking these cases to go to trial, I'm seeing judges will say, I may be willing to put in place a temporary order that reflects the current inflation, but I'm not going to do anything permanent, because if this goes to trial, it'll be 2+ years from now, and by then we don't know what the economy is going to look like.
Yeah. And I think before we move on to modifications, I want to just briefly mention and kind of explain maybe more thoroughly what I was talking about, and that is why you can at least afford not to take action in inflation. A great example, I've got a case right now in a divorce where, as we all know around the country, real estate had gone through the roof over the last, let's say, 18 months. I mean, we're talking hundreds of thousands of dollars on just some middle income, middle America properties that it doubled, and crazy numbers, definitely a bubble. Well, that bubble has burst to some extent. What we're seeing is, and a great example, had my client filed at the peak, he's going to have to buy his spouse out of the real estate on the equity. At its peak, maybe it was worth $560,000. Well, we've waited. The market's kind of tanked a little bit in the area. So now we got an appraisal and it's at $260,000. Inflationary pressures, he can't afford, he's thinking he can't afford maybe the cost of divorce. But if you think about, had he taken action when he could most afford it, he would have had to actually pay more as a result of that divorce, because splitting an asset at its highest point, than had he now taken action, which we are, and now he's selling, and I put that in air quotes, his property or half of that to his spouse for something far less, simply because of inflationary pressures, because of economic downturn in the market. And so what I mean by saying you can't afford not to file, this is some of the times where you have to have that consultation, talk about strategy. Keep an eye out. We're actually dropping a podcast, a video cast, that's going to be talking about the financial impacts of divorce and things you need to be thinking about. And this is one of those, the effects of property distribution. Sometimes you have to buy someone out. You don't want to sell the property. You want to keep it. In this case, my case, the client wants to keep the property. So we're going to split the equity, and that's going to be done in the form of cash or other payments over time. So that's a classic example that may affect all of you out there, where you can least afford not to file simply because of the economy. Now, inflation's giving you the mixed signal. Your heart is telling, your brain's telling you one thing, your heart should tell you the other. So consultation. That's why the topic is to stimulate your thought process, to strategize with an attorney to say, is this the right time? If not, we'll tell you it's not the right time. If it is, you need to think about it, but doing nothing is really not the solution. So, which brings us to modifications, because I think it's similarly, you need to be thinking about it. So Rachel, I want to talk about timing for a modification. There's guys watching thinking, hey, I got a job cut, or I got a wage cut, or bonuses are no longer there, or my income's down, my expenses are up. And it may be a custodial parent, like we may represent a guy who has custody of his kids and he needs more child support, or he wants to pay less child support for a number of reasons. So the age-old question really is, and everyone watching now is, how long do I wait, Rachel? When do I file? When should I be thinking about filing a motion to modify my support? Income down, income up, inflation. What is kind of your thoughts and timetable?
So I would highly recommend talking to somebody kind of along your lines in terms of when to file a divorce. In terms of when to file a modification, everybody's case is fact specific. Your job is facts, specific. You're going to know your circumstances in terms of your income and the likelihood of your income going up, going down more than anybody else. And so you need to, if you think if your income has gone down, or if you think if you're the primary caretaker and the other person, the payer spouse has gone up, you really need to reach out and talk to somebody strategically in terms of when to file that, for several reasons. What you don't want to do is file, too late, because in most states, at least in Illinois, you can't get retroactive credit until you file. So whether the support's going to go up or whether the support's going to go down, until you file that motion, you're not going to get retroactive credit in Illinois. I'm not sure on the other states. The other issue is you don't want to file something too late, and then let's say your income has gone back up or the payer spouse's income has gone back down, because then you're out of luck basically, and you've proceeded, you've filed these motions, and then the support isn't going to change, or worst case scenario, it changes in the opposite direction of what you want it to change. Kind of along what Matthew was talking about is this court backlog. Well, we've seen some cases that things have gotten backlogged because of COVID. And so now we're, trying to come out of that and these motions to modify support. And maybe it's not, they're not relevant anymore because it's been 2 years since the original motion was filed. So again, I think you're going to know your income, you're going to know how your income it looks in the future. So you really need to reach out and talk to somebody about that.
I think you're right. The whole too late is very relevant. Even at divorce stage, where I've had a conversation, and the client's like, "Look, the marriage is over, no doubt about it." And I'm like, "Are you sure?" "Yes." So, healthy spouse, and I'm thinking, okay, but he's like, "Well, maybe I should wait. I really can't afford it. I want to wait till my situation improves." I said, "Well, if your spouse gets sick, gets injured, gets in a car accident, becomes disabled, has long-term COVID, now you're in a whole different situation. Again, filed too late. Take action when the action's ready." And that's really, and I know that's a hard trigger to pull, but you've got to do it. And I think, but the same also goes for filing too soon. And I think Presley even mentioned kind of a more permanent change in circumstances. For example, "Oh, I just lost my job, but I know I'm going to get one in another week." Well, maybe you pull the trigger too soon and you filed, and the judge is like, "Look, I don't have a substantial and continuing." There's a word, continuing change. I don't know if that's the standard in Illinois or not. So maybe filing too soon could be it.
Right. You can file too soon. For instance, you might have an employee who is more seasonal. So somebody might have a job where the last 3 months they haven't made as much money as they normally do. Maybe they work overtime in the summer. So if you file your motion to modify based on your pay of October, November, December, well, the judge is going to probably look at your year-to-date statements, your last year's, W-2, and see, okay, well, you make up that time. Yeah, maybe November, December, January, you have half the income that you normally have, but come the summer, you're going to make up that time. So you have to be strategic in terms of what, are you going to make up that time in the summer or however seasonal your job may be?
Yeah, I agree. And it is one of those where you can make a decision and you can think to yourself, "Oh no, it's not the right time." But again, it's doctors and lawyers have very similar approaches. And that is, we want to solve a problem. We want to cure you of your ailment, but you can't cure yourself by not going to the doctor and just try to guess it. It's the same as a lawyer. It's the best hour you're going to spend just having an idea of your situation. And when we get questions here, oftentimes it's people who have not retained counsel. They understand their situation, but they need some guidance. And that's what this is really about, is education, preparing you and equipping you for maybe something that's going to happen now or in the future. And so let's talk a little bit about the individualized nature of modifications, because it's not a one size fits all. Every modification I have is very different, very unique, in that whether it's a judge by judge, county by county. I've even told clients, "Hey, depends on this modification, depends on what judge we draw," because I know behavior is very different, especially when it comes to modifying spousal support. At least in Missouri, there's no formula. I have always said that you can, 10 times out of 10, I may get 10 different results with 10 different judges on the same facts, and they may be very different, just simply because judges are human and they're derailed by emotion and with no formula. So let's talk a little bit about the individual nature of timing for modification.
So yeah, definitely, I agree with you. And you could get a different result from the same judge depending on the day that you're in the courtroom. I mean, as you said, judges are human. They have spouses, they have kids, they've seen 10 other cases that day before we go in there. So you just never know. So I always like to kind of run through scenarios with my clients, because even though in Illinois, there is a formula and you input the two different parents' income into this formula, and you input their health insurance and how many kids and the overnights, and then this formula spits out a number. However, every case I have done with this new formula, and it's been about 5 years that Illinois has had this new formula, you always get different numbers. And so even though it's supposed to be this great math equation, it's always different. And so it varies. People are going to argue about what their gross income is. Is it your gross income from your pay stub from February? Is it your gross income from last year? Is it your gross income from the last 3 years? And so there's just a lot of human input that goes into that calculation. Then in terms of how the judges rule on it, does the judge take, the person asking for the modification versus the person who's asking not for the modification, and then somewhere in the middle, or, and then the other thing in Illinois, and I'm not certain about other states, is, but you have your child support, but then you also have your extracurricular fees. You have your daycare fees. And are you including those in child support? In Illinois, those are additional. But then there's the argument is, okay, what's included in extracurricular? Is that select sports? Is it the uniform? Is it the notebooks? So you have all these additional things. And every judge then, kind of getting back to how the judge sees it, is different. You may have a judge that personally values all these select sports, all these extracurriculars. And then you may have a judge who says, well, you know what, whatever parent wants that child in those extracurricular activities, that's the parent that's going to pay for those. So it's really kind of, all over the board a little bit.
You mentioned and brought back a memory when you said same judge, same facts, different result. I have just that, back-to-back days, amazingly identical facts. I went in successfully, got a good judgment for my client. Very next day, exact facts, judge went the other way. And I called the judge out and he kicked me out of the courtroom. And I said, Judge, you just gave this order. And I flashed it in front of him, said, here's the order. And I said, okay, we're just going to try it then. And eventually we came back full circle, but it's just the unique nature of our system with these judges. You will get different results. And so to wrap this topic up, let me talk about guys who are watching that are receiving child support, right? Inflation. Everything's costing more. I get it's temporary perhaps, but when is it, or how should you approach, if you have somebody watching right now, how should they approach a modification to get more increased support? I would imagine it depends on how long it's been since the last order, since the last modification.
I think what I would do is I would tell them to definitely start writing down the expenses. Not so much that you're going to use that as evidence in court, but I think to track it for yourself. And you want to see what type of increase there really is before you go to court and try to modify to try to increase. Because again, in Illinois, you plug in the numbers. So you want to see if the parent who's paying support, it's really going to depend on, has their income gone up in terms of whether or not they're providing more in child support. If you're not getting those extracurricular fees, if you're not getting the school fees, daycare, that can be added additionally. So that's where I would say start tracking to see, have those expenses gone up and how much, to kind of do a cost benefit analysis in terms of asking for an additional amount of support.
So Presley, go to you now as we talk about, and you hear this a lot. On Tuesdays, we get job loss reports, we get unemployment reports, job growth, how many jobs are out there. It's kind of a phrase we've become accustomed to since COVID in 2020, and that is job loss. So, and we were talking off camera, the difficulties in Florida particularly, but maybe it's got to be an issue for you, particularly with clients who come to you and say, hey, I lost my job. I've got a child support order. I've got a spousal support order. What do you do? Kind of then talk through the standard. I know you alluded to it earlier. but kind of what are the difficulties, at least particularly in Florida?
So in Florida, as I mentioned earlier, you have to show that there was a substantial change in circumstances since the entry of the last order. The change has to be unanticipated, it has to be involuntary, and it has to be permanent in nature. So to any, potential client out there, any individual who's lost a job, my recommendation and advice is, try your best to secure additional employment. If you have obligations to your former spouse or to your children, then you want to make sure that you're maintaining those obligations that you already have. I know that it was particularly hard on a lot of my clients that were in the restaurant industry at the peak of COVID. And those were the ones that I really saw that were hurting the most from it. But we took those cases in front of the judge, and the judge said it's not permanent. We don't know how long a pandemic is going to ultimately last. And it's kind of the same situation here that we're dealing with inflation. We don't know exactly how long we're going to be in this situation. But to anyone who has lost a job or is going through that, like I said, my biggest piece of advice is just try your hardest to find employment so that way you're meeting your financial responsibilities.
So scenario, we couple timing in with this decision. Lose my job, I begin the search, takes me a couple weeks, couple months, I find a job, but I'm making far less. And it's kind of about the only job offer I've received. Talk about timing and kind of when do you take action? And I guess when in light of your observations and experience in Florida, where it's got to be this more permanency. So that's a scenario that is fairly common for guys where they lose a job, spend some time, find a job, get a job. They're just not making what they were making.
And we do see that a lot, generally speaking, just across the board. If it's been about a year, that's when I see judges starting to take action on that. But if you get a job and you're making less and it's been about that, year threshold, then that's certainly time, in my opinion, to go and get that modification.
And I do think it's a little different, obviously, around the country. No doubt Florida seems to be kind of this harsh, wait a year. And it does to me seem like, wow, it's a long time to get to that permanency level. Understand it. But I mean, if a guy's done exhaustive efforts in a specialized area and they're just not making the kind of money, you definitely should have that consult. But let's talk about the one question guys have. COVID payments kind of interrupted this idea and this thought about what you do because it's supplemental income in addition to unemployment. I'm out of a job. I have obligations. I can't afford to pay the full amount. Let's just say it's $1,000 a month. I don't have it. I've got, such a little bit amount of money coming in. I got to pay my rent, my mortgage, whatever it is. Got to keep the lights on. Do I pay nothing? Do I pay something? That is always the question. Most guys come to me, and they haven't paid a dime. I can't afford it. I got to pay my bills and I got nothing left. In fact, I've got credit card debt. So typically what do you suggesting? And obviously it's not a one size fits all, but typically what are you thinking?
So it's certainly not a one size fits all, Scott. In this situation, I would always say pay what you are able to pay, because ultimately, if your spouse files a motion for contempt for non-payment of child support or spousal support, the judge is going to look to see whether or not you actually have the ability to pay, or if you've been making those good faith payments. So my biggest piece of advice to anyone in that situation is to make sure you're always making those payments, because the last thing that you want is to not make those payments and possibly end up in jail for not making those payments. Then you'll have to post a purge amount, which is ultimately what you are able to pay. So just to prevent that in the long run, pay what you can pay now.
I think that goes with where I have a client come in, we do a financial analysis, we go through their bills, we do what we call an income and expense statement. What do you have? And then now we then decide what can we reasonably cut from the perspective of a judge, whether it's eating out, entertainment, vacation, clothing, kind of the luxury items, right? And I had a client where we decided, okay, $25 a week is what we can not only pay, but what we can factually support. If I were to go to the judge and say, where'd you come up with that number? Well, here it is, Judge. There is nowhere else to get any more money. We've cut everything out that's discretionary. We're because we're first paying our utilities, our expenses, our food, which is lower than normal, and everything else, mortgage, automobile gas, everything. And so we were successful in that. Was at least the minimum to keep us out of jail, as you suggested, out of contempt, in good graces with the judge. It doesn't stop the bleeding, but it does, I'm going to ask you in Florida, is there retroactivity? If I file for a modification to either stop spousal support, decrease it, even though I'm paying, let's just call it $100 a month, if I'm successful, can I get that order all the way back to the time I file or it's served?
So in Florida, retroactivity only goes back 24 months. So it just depends on the timing of it, when it was filed, how long the case has gone on for, and then certainly doing those calculations to support it. I know that every state, I know Rachel indicated this earlier with Illinois' calculation. I know Maine probably has something different, but Florida has our own standard that we use to calculate those figures. So it's just something that we have to take into full consideration.
Yeah, and we have retroactivity. There's no time limit. So I think you need to check with your state. There's usually a form of it around the country. And I think that's important. So which kind of, as we talk about retroactivity, Matthew, I want to talk to you a little bit about reducing spousal support obligations. That's a big one. I'm in the middle of one of those right now, where we have someone who's been about 4 or 5 years since the order was entered. So I guess that's the question in Maine. First question guys have is, Matthew, I owe $1,000 a month. She's not done anything to better herself. What's the standard? What do I need to prove? What is the legal standard to prove?
So I think it is important first to go over the different types of support that courts in Maine will order. So the first type of support is known as general support, and that is, when people think of alimony in Maine, they call it spousal support. That is your the general support that a court will order to try and allow the spouse who is receiving the support to live the same kind of lifestyle that they lived during the pendency of the marriage. And in Maine, general support is generally not given if the marriage was less than 10 years. If it was greater than 10 years, the standard is that it can only last as long as half the length of the marriage. So if you had a 10-year marriage, there could only be a 5-year general support award. And if the marriage was above 20 years, then there is no limit. And that's when you'll see judges award lifetime support orders. Then there's transitional support. And that's actually the most common form of spousal support in Maine. The court, sometimes they refer to it as rehabilitative support. And the goal of this support is to allow the spouse receiving the support the time necessary to transition into a new job or to rehabilitate the education skills or any employment skills or training needed to re-enter the job market and to become self-supporting. And that will last as long as the court believes that it's necessary. So it could be an award of just a few months. It could be an award of several years. If there's a spouse who completed 1 year of college and now she plans on going back to finish her degree, the court may award 3 years of transitional support to allow her to complete that degree. So it really varies depending on the circumstances of the case. There's then reimbursement support, and that support that is rare, and that is only awarded when the court has determined that there has been financial misconduct during the marriage. So, for example, if one spouse drained all of the funds in the bank account, in the joint bank account, and then went to Vegas and put it all on green zero at the roulette table and lost, and now they're both broke, the court might award reimbursement support to make up for the draining of those marital assets.
And maybe real quickly, you mentioned education, further employment, further training. Is that a continuing obligation? It is here in Missouri. It's one of the bases that we often use to modify or terminate support is they've done nothing over 4 years, 5 years, 3 years, 2 years to do anything, to get better, to get training, to find a job. Is that a continuing obligation in Maine?
It's a continuing obligation to the extent that during the marriage, there, for example, if you had, a stay-at-home mother or a stay-at-home father who during the marriage, didn't work at all, if the court awards, rehabilitative or transitional spousal support to allow them to gain these skills necessary to then, re-enter the workforce, then there is an obligation that they are actually going to take proactive steps to try and re-enter the workforce and become self-supporting. If this is a situation where it was a 20-year marriage and there was always a stay-at-home mom or dad who never worked, and the court has issued a lifetime spousal support award on the grounds that they never worked during the marriage, and so we're trying to give them the same kind of life they enjoyed during the marriage, then there would not be an obligation to become self-supporting outside of the support award. So one thing that I was going to mention, and I'll mention it now, is that when you're looking at whether to seek to modify an award of support, it is really, really important to look at the circumstances at the time of the divorce judgment, and especially whether this was a trial or whether it was a settlement agreement, because I have found in Maine that when an award of spousal support was part of a no involuntary settlement agreement, the courts are less likely to disturb that award of support because the judges will say, this is an amount of spousal support that the court didn't force you to offer to her or pay to her, that you agreed to do it, and now you're coming back and saying, no, I shouldn't have to pay that support anymore. So judges, they actively look at the circumstances surrounding the divorce judgment itself, whether it was through a trial, whether it was a settlement agreement, why the support was awarded, and that's a big factor they will take into consideration. So I've had clients who have said to me, I really want to settle this case, and I just want everything to be done, and I really don't like the amount of spousal support I'll be paying her, but I figure that going on down the line, I can always just go back to court to have them get rid of it or to have it modified or reduced. And so I always explain to clients, and I think it's extremely important that if you are settling and when you are crafting this final agreement, to make sure that you are comfortable with what you are agreeing to and what you are signing, because if this is a situation where you sign the settlement agreement, it gets finalized, and then you're immediately regretting the amount of spousal support that you agreed to pay, you're not just going to be able to turn around and have things change. And in Maine, the actual law up until 2013, the requirement was it was as justice requires, the courts can modify a support award. And that was really general and broad. The courts didn't like it because how do you define as justice requires? So in 2013, they changed it so that now the requirement is that there needs to be a substantial change in circumstances, which is not much less broad because there's no definition as to what constitutes a substantial change in circumstances. And I'll get a lot of clients who will, come in and they'll say, my spouse makes more money than she did, or I make less money. Can I get my support obligations reduced, or can I get more money from her? And because there is no definition of, substantial change in circumstances, again, it goes back to what were the circumstances at the time of the divorce. And the judges will also, they'll look at awards differently in terms of, let's say you make 50,000 a year, and you are ordered to pay spousal support to your wife, who makes 40,000 a year, and now her income has increased. So let's say she makes 20,000 a year. She's way below the poverty line, and her income has increased by 20,000. And now she's making 40,000 a year when she did make 20,000. There's case law in Maine that says that is a substantial change in circumstances, because going from 20,000 to 40,000, that 20,000 increase is a doubling of her income versus previously she made 150,000, but now she makes 170,000. The court is likely to say, well, that's really not a substantial change in circumstances, because when you're at that level, the 20,000 isn't as significant. So in Maine, it's going to vary depending on the circumstances of the case, what the income level was before. And one thing that I would caution with clients too, when we go back and consider the circumstances at the time of the divorce, was if the court imposed a support obligation on you and you want that reduced, what was your income at the time of the divorce? Because hers may have gone up, but yours may have gone up too. And it may have been a situation where the judge didn't impose the amount of support that he normally would because he didn't believe that you could afford to pay it. Or this could have been a situation where you had to pay child support as well, and that reduced the spousal support award because you couldn't afford to pay full spousal support plus child support. But now the kids, they've all graduated from high school and moved on. The child support payments aren't there. So if you file a motion to modify the support, the judge may say, well, you no longer have these child support payments, and now we're going to increase the spousal support that you owe. And so that's why I think it is really important when you're considering whether or not you should file a motion to modify. I think it's really important that you consult with an attorney who can look at these factors. What were the circumstances at the time of the divorce? What are the circumstances now? Has that met the threshold of a substantial change in circumstances? And also, what is the risk that the court is going to come back and say, sure, there has been a substantial change in circumstances, but this isn't a one-way street. It goes both ways. And so, we're going to order you to now have to pay more support.
Yeah. All right. I've got a few questions. Let's go ahead and jump right to those, and then we'll be near the end of our virtual town hall. So Presley, I'm going to throw this to you out of North Carolina, although you're in Florida. North Carolina is a 50-50 state, although that's what at least the viewer is letting us know. Retired, married for almost 40 years. Soon to be ex has taken the savings and purchased a $310,000 condo in another state, South Carolina. She paid cash, depleting all liquid assets, and she put it in her name only. They also have a home in North Carolina, assessing for about $450,000 with a $180,000 mortgage. The question just is really this: is it possible to get more than a 50-50 split? And then we can all chime in if we need to. Misconduct or whatever it may be, is a division, an unequal division of assets, at least in Florida. What do you need to do? Can you do it? And I'll give my perspective in Missouri because you can. So go ahead, Florida.
So in Florida, you absolutely can have an unequal distribution. You have to plead for it in your initial petition for dissolution of marriage. You can always go back and amend that later if something comes up. And in this case, I absolutely would say that I would request unequal distribution, because that's a lot of money and that's a really big asset for your soon-to-be ex-wife to just go out and purchase during the pendency of your case. I'm not sure exactly how that would work in North Carolina, but in the state of Florida, I would absolutely go after unequal distribution.
I think there are a number of things, as you were talking, that come to play for me, and that is timing. It's now go ahead and file. The marriage is over, file, because in Missouri, you can do unequal distribution based on a number of factors. But I think for me, you're depleting all the cash, using all the financial resources. She's now set herself up to have no mortgage, and you have a mortgage. That is, to me, another justification for perhaps a greater disproportionate share. I don't necessarily care that the deed is in her name only. In Missouri, marital assets are everything acquired during the marriage.
Same in Florida.
So it wouldn't matter. But I think for me, if you concluded that the marriage is over, get a consult, get filed, start taking action, and plead for disproportionate, introduce the misconduct, financial waste, mismanagement, whatever it may be, taking the assets, taking all the cash, don't know what's left. I think that's all the evidence I would plead and definitely take action. So,
and I would like to add one more thing to that as well. In the state of Florida, you can also request for an injunction against disposal of assets. So if something like this had occurred, I would ask the court to immediately issue an injunction against the other spouse. So that way they will not do that again or attempt to do anything else during the pendency of the case. So that's another reason why you would want to hop on that ASAP and get something filed with the court.
Yep. All right, Rachel, I'm going to go to you. Jason has a job that requires a very long commute and has been hit especially hard by high gas prices like everyone else. Fortunately, he has a good relationship with his ex, and she's okay with reducing the amount of child support he pays while prices are high. Red flag.
Big red flag.
Is an agreement between the two permissible, or do you have to go to court?
You absolutely have to go to court. So this is a pitfall that a lot of people fall into. And on one hand, it's great to be able to work with your ex-spouse and have that relationship. It's good for you. It's good for your children. However, it's a huge red flag. Anytime that you have a out of court agreement modification, you have to get it signed by the judge, and it has to be filed with the court for it to be enforceable. And here's the big issue. She agrees now. So let's say you're paying $1,000 in support. She says, oh yeah, just pay $500. Don't worry about it. So then you pay $500, and a year, 5 years, whatever down the road comes, and she says, I never agreed to that. If it's not signed by the court, you have back support. And not only do you owe the back support, but you're going to be on the hook for the interest as well on that amount owed. Even if you have, I've had cases in Illinois where even if we have an email or a communication that says she's agreed, or, checks, whatever it may be, unless it's a clear case law in Illinois, at least, that it has to be, any type of modification has to be signed off on by the court for it to be enforceable. Yeah. So it's a huge red flag. A lot of times there'll be modifications, or, hey, instead of giving me the full $1,000, you just pay health insurance, or you pay for this cost. Don't do it. Pay that full amount, whatever that amount is, and then get the money, from her, or you've got to pay that ordered amount or get it modified by the court.
Yeah, that's huge. As soon as, that's not an uncommon thing where everyone thinks, well, they're just trying to be kind to each other. you'll just get yourself into trouble. And it's very quick, very easy to do, get it submitted to the court. Mike or Matthew, Derek, and I'll summarize Derek's question. And it really comes down to this. In Maine, particularly, and this is a common question, how often can you modify child support? I mean, some say they've heard, oh, you can only do it once every 3 years, or once every 5 years, or once every 2 years. Is it really just the standard? If you meet the standard every 6 months, every year, can you just keep filing, whatever that may be?
So in Maine, the standards as it comes to modifying spousal support, this is actually the one instance where the courts have actually defined what a substantial change in circumstances is. Basically, the court has said that after 3 years since the original child support order was issued, either party can ask the court for a modification at any time. And in Maine, the spousal support is statutory. It's a statutory formula where they take the combined gross income of each party and then they apportion the spousal support based on the percentage that each party contributes to the combined gross income. So to keep things simple, if one spouse makes $60,000 and the other spouse makes $40,000, their combined gross income is $100K. So the spouse who makes $60,000 is responsible for 60% of the child support calculation. And in Maine, when I say it's statutory, what I mean by that is they actually have a spousal support chart that shows it has a list of combined gross incomes on the left, and then there are columns on the right for if you have 1 kid, if you have 2 kids, if you have 3 kids. And so what you do is you match the combined gross income with the number of kids, and then it gives you a number, and that is the general child support number that covers things like food, clothing, general household goods. And then you add on top of that, you add the cost of childcare, health insurance, any extracurricular activities, things like that. And then you get the total amount of child support that is owed. And then from that total amount, you divide it based on the percentage that each party contributes. So if the total amount of child support winds up being, let's say it's $1,000 a week, which is high, but just to keep things simple. And then one party is, making 60% of the combined gross income. That party is responsible for $600 of the child support, and the other party is responsible for $400. So after it's been 3 years since the divorce, you can at any time file a motion to modify. And all the court does in that situation is they just redo the calculation. Mm-hmm. If it is prior to 3 years since the initial divorce judgment, the court has said there has to have been a substantial change in circumstances, and they define that to be a 15% or greater change in the income of any of the parties. So if you make 15% more or 15% less, or the other party makes 15% more or less, then you can file a motion to modify child support. And if that doesn't happen, then if it's within 3 years, you can't file. And going back to Derek's question, because he specifically saying that this could be a constant back and forth in terms of child support. Well, during the first 3 years, it won't be a constant back and forth because, again, there has to be that 15% threshold. And after 3 years, it absolutely could be a constant back and forth because you can ask for a recalculation at any time. I would I find that in my experience, it typically does not become a constant back and forth because, hiring an attorney and, for changes that are only going to be minor is typically, I find that, people don't want to go through that expense. And they will only do it if there is something major. But because the courts view child support as for the children and not for the other party, they want you to, freely, once you're past that 3-year threshold, they want you to be able to freely ask the court for a new calculation because they want the children to be getting as much child support as they are entitled to.
Got it. All right. Well, we've run out of time. We got actually overtime. So I appreciate everyone attending. Keep an eye out for the next virtual town hall and also for the Men's Divorce podcast. It'll be coming out. Talks about the financial impacts of divorce. It's actually a 4-part series. You're not going to want to miss it. It's a video and podcast. Watch for it to be dropping soon. So until next time, have a great week.